Hey y'all, it's David with I'm So Offended. This is part 2 of the motion to enforce. As you heard in the other video, it was, just my argument, my paperwork, and, we were talking about, you know, I was basically filing a motion to enforce for them to produce my daughter because they were threatening to not produce her. So that would have been custodial interference. And they were pretending like they couldn't read the court order. And that's something that they do. They pretend like they don't know what it means or that it means something differently in order to try to get away with not following it. It's BS. That's what they do, and they get away with it all the time. All the time. It's weird how baby mama has an attorney who has a law degree, who has been practicing law for years and years and years and years, but yeah, he doesn't know how to interpret court orders. So it's all just tactics. That's it. It's all just tactics, and nothing ever gets done to them. But anyways, we're going to continue where we left off. I finished my argument, my statement, my documents, and as always, I'm not an attorney. This is not legal advice. This is all informational, educational purposes only, for entertainment purposes only. I'm not liable for anything you do, see, follow, any of your actions, and whatever it is that I do doesn't mean you're going to get the same outcome. But this is just how I do what I do, and how I respond to the things that happen to me. So here we go. This is the other side's argument.
Well, the fact Mr. Quintero has filed his motions to dismiss today confirms that our emails to him with the pleadings for today were in fact received, and as I noticed, our motion modified. So the statement that Mr. Quintero has made that he believes the 1 year Judge Sklar set out ran yesterday makes timely our motion under 411 that it's been a year asking to modify Judge Sklar's order. So Rule 83 isn't necessary, it isn't relevant.
Attorneys are allowed to lie. So the first thing he did was open with a lie, saying that the bond expired yesterday, which was a year from the ruling, so our ruling is timely. No. Just because we're arguing it after a year doesn't mean it's timely. It needs to be filed timely. He filed it 2-3 days before the year. So he wants the court to believe that they're stupid and that it just does like they know. He knows he's wrong, but he's gonna make his argument anyway. Just because we're arguing after a year from the last order does not mean that it's timely. It has to be filed timely. He knows this, but he's still making the argument.
To you today under Rule 411. As Mr. Quintero has confirmed, Judge Sklar's order in October of 22 was that he should have the opportunity to return to unsupervised parenting time, but only after completing therapeutic and supervised parenting time for several months. Now, what he has done is complete and has participated in supervised parenting time. What Judge Sklar ordered was that he leave therapeutic and begin to exercise unsupervised parenting time, but that prior to doing it, he must post a bond in the amount of $5,000. This was all supposed to happen months ago, Your Honor, that he post the bond and that all the parties could see that he could exercise, with the protection of the bond, unsupervised parenting time, and that he do so in order to make sure that he brings the child back. He challenged that bond. We litigated extensively. This court found just recently that under the circumstances, this is Judge Sklar's order. Under the circumstances, the court finds significant conditions will be necessary to protect both Luz and Miss Hadley from further harm. And yet today, he stated to you just a few minutes ago that these are past false allegations. Even today, he does not acknowledge what he did. Judge Sklar ordered the bond in order to remedy, and he created a timeline that Mr. Quintero refused to follow by not posting the bond. His effort to seek relief
refused to follow. Like again, they're gonna say whatever they want to say, and they're gonna lie. All right, it wasn't refused. I didn't have the money. I didn't have the money for the bond. Right. So the one part he did have correct was about the timeline, because there was a timeline that was put in place in the other order. Had I been able to pay the bond, but I couldn't do the timeline, which was exercise like 8 hours of unsupervised time, because I wasn't able to pay the bond. So I couldn't continue with that. So he only had 1 point of validity in his argument, which was I wasn't able to do the timeline.
This court resulted in this court making a finding that those conditions are still present and that the bond should remain in effect. Your finding also include that he intentionally misled this court and that you were unconvinced that he would refrain from engaging in similar conduct in the future, and that there is a substantial risk that the petitioner will commit future acts of custodial interference. That's from June of this year. And again, the path was never obstructed, that he could move to unsupervised time, and he could have moved to unsupervised time today had he followed Judge Sklar's order and posted the bond. He did not, and so we never had the opportunity to complete the process Judge Sklar laid out and that you found recently needed to be maintained. All we are asking for, Your Honor, if he doesn't want to do supervised time, swell. I mean, that's up to him if he doesn't want to exercise supervised time. But before he can exercise unsupervised time, we ask that what Judge Sklar ordered, that order be modified to extend the period of time to protect Luz and to protect our client, and frankly, to protect Mr. Quintero from himself. And we impose the bond condition and extend the period of time for another year. Then the schedule in place, he can exercise and move from there. If he wants to pay for supervised exchanges, bear in mind, he made it clear that the reason he wanted supervised exchanges is to protect himself against what he claims are more false allegations. Your Honor, I want to make clear that the concerns here about just trusting Mr. Quintero have been tested, whether or not he is trustworthy today. He has chosen again and again recently to set himself above this court's orders. On money fine, he could say, I can't afford to pay it. But you ordered him again and again to do things that were within his potential to do and which go directly to us knowing whether or not he has the resources and the capacity to take this child. And you ordered him to provide us with his business contracts, invoices, and receipts for his equipment.
They have no argument here. He's talking about stuff that was already litigated, that was like from before. Like, they have no argument here because their Rule 47, when it comes down to it, is about the present danger. Okay? There's a lot of fluff in what the attorneys do. Okay? The only validity from his argument was the timeline that the previous judge laid out. Outside of that, judge ordered bond to be lifted a year later. That was it. Other than that, he's talking about things that have nothing to do with anything right now.
He did not, you ordered him to turn over the documents related to the property in Mexico, so we know exactly what his association is with it, how much he paid for it. You ordered him on a China doll affidavit to pay attorney's fees for vexatious, which makes it even more humorous that he wants the same benefit. And you made a determination that he'd intentionally misled the court. The point is, Your Honor, even on records and documents exclusively in his possession, he refused to comply with your orders. His statements are he doesn't have to. His response to the China doll affidavit in writing is he doesn't have to pay for my client's attorney's fees because they're her fees, completely ignoring your order. So we're not talking about somebody who could be trusted that if you order him to not take the child, to return the child, he'll do it. You're talking about somebody that whenever he's confronted with any requirement that he do something he doesn't want to do, he doesn't. And that's why we're here in the first place. His response to our suggestions that he post the bond before this parenting time was to say, I will have these orders in my possession for a keep the peace officer that I've requested. When your client commits a custodial interference, I will ask that she and you be arrested and charged with a class 6 felony. So he is ready to embrace the law when he thinks it'll serve his purpose. But when it's his requirement and obligation to follow the law in order to protect this child and my client, he doesn't have to. So, Judge, we're asking you to not take his word, but to hew to the spirit and the letter of Judge Sklar's intention that he would move to no bond unsupervised time only after a period of compliance that gives everybody confidence that he knows and will follow the law. So we're asking nothing more than the current requirement that before he moved to unsupervised time, by posting a bond ensuring his return of the child will be complied with. We ask that you do this for the period of a year. If we can have him exercise unsupervised time for the course of a year, then at that point, it makes perfect sense to drop the requirement of him posting a bond. But we ask for nothing less than that now. As far as continuing supervised parenting time, we've included that in our request based on the court's preference. I would note the 5 H's does report, as Ms. Dr. Stobadoya told us, that Luz has a great playmate in Mr. Quintero. He is a great playmate.
He's not making any arguments towards the rules that he invoked. Okay? There's a lot of fluff here. And this is what my baby mama's paying for. Fluff. But when it came down to what was material, they didn't have it. Okay? And if this is what my baby mama's going to pay for, then so be it. Good luck with that. I kept it about the rules, about the material facts.
So, but he's not a father in any of the traditional senses. That was the testimony Dr. Stobadoya offered. It still is the problem. If we want to move to give him the opportunity to exercise unsupervised time, I understand, we accept it. But we do think it is absolutely essential, based on this court's findings and Judge Sklar's ruling, that we do not go to unsupervised time without having a bond in place for a period of time to protect the child, my client, and to build the confidence of the court that he will comply. Thank you.
All right, thank you. I am going to use my judicial discretion to have the 5H supervised visit reports entered as Courts Exhibit 1. And for the record, that is the visits from June 2023 through October 2023.
This is the judge here, right? Now she's going to make her ruling. And then the reports were the supervised visit reports because, I had been doing supervised visits for like, I don't know, for like 11 months or something.
So that's Courts Exhibit 1. I do find that when Judge Sklar entered his under advisement ruling on October 24, 2022, it was his intention to follow a incremental increase in Mr. Quintero's parenting time with the child. First therapeutic parenting time, then supervised through the 5H's, unsupervised would move only upon posting a bond, and the unsupervised with a bond in place was expected to incrementally increase and have a test over the course of 9 months how it was going unsupervised. We never got to that point. Mr. Quintero never, over the whole past year, has had unsupervised time with the child. However, his time supervised with the child has gone exceedingly well.
Exceedingly well. The court takes these reports from these agencies seriously. So that's why when you guys, it sucks that we have to go through it. It sucks. And I talk to so many of you that are dealing with and it's all the same. Baby mama won't let me see my kid. Won't let me see my kid, won't let me see my kid. And we get angry and something happens or whatever it may be, or it's just a false accusation. That's what it usually is, and then there's the temporary orders and they order supervised parenting time and whatever. All right. You make your arguments in court, and if you lose and if you have to do supervised parenting time, do it and be the absolute best at it. We can come back from that. This is proof. You're listening to actual proof here. We can come back from that. I came back from nearly 11 months of no contact to a gradual increase in time and supervised time. And now, from that, I've come back.
Regained his child's trust. I do have concerns about Mr. Quintero's willingness to abide by court orders, as evidenced by his past track record of not following court orders. However, in the totality of the circumstances, I do find that over the course of the year, with reestablishing the connection, there is good cause to lift the.
Hold on. This is where the shit hits the fan. And this was the ruling. This is what we're basically hearing right now, what she's saying. Here we go.
As evidenced by his past track record of not following court orders. However, in the totality of the circumstances, I do find that over the course of the year, with reestablishing the connection, there is good cause to lift the bond requirement and allow Mr. Quintero to move to unsupervised parenting time with the child. However, because he has not followed the incremental increase in parenting time, I do not find it appropriate that he has earned the right to return to the November 8, 2019 parenting time schedule. Where we are right now really is at Judge Sklar's 3-month interval where he was having 4 hours per week on Wednesdays from 3:30 to 7:30. That's where we are today. The only difference is that I'm going to find he's eligible to graduate to unsupervised time on Wednesdays 3:30 to 7:30 without a bond, and I'm intending to follow the rest of Judge Sklar's incremental increase of parenting time. All of this is going to be based upon the court's own motion under Rule 85B6 for relief from a judgment, because.
And actually, like 30 seconds ago, the moment she said that she was lifting the bond, the baby mama started crying. Like, yeah.
Mr. Quintero has not had that full year of graduated, incrementally increased parenting time, so we are nowhere close to getting to returning to the November 8, 2019 parenting schedule. So in other words, I'm ordering effective immediately today, the bond requirement is lifted. Ordering starting today, Mr. Quintero is going to unsupervised parenting time with the child for 4 hours per week, 3:30 till 7:30 p.m. on Wednesday. And that will be for 3 months. After 3 months from today, following along Judge Sklar's schedule, it's at page 10 of his ruling. Mr. Quintero's 4 hours per week will expand to 8 hours. 9 months. At the 9-month interval, his parenting time will revert to the time set forth in the November 8, 2019 ruling. So just to be specific, today is October 25. That means...
Can I be heard on just that timing?
Yes.
Okay. I understand the court's ruling. I'm not quarreling with anything you've said except the timing. In his October 19th email to me, Mr. Quintero threatened to call the police and my client arrest today if she was not at the site of the exchange. Let me read it so there's no... I gotta get my glasses. Give me a second.
So you want to change today to a different day?
So we can start next week, or if you want to pick a different day that my client can.
Can you do it tomorrow or Friday? To make up for today? I heard you, Mr. Quintero. I'm asking Mr. Wintery.
I'm sorry. We're not talking about we're not
a makeup for missing today. Can you do it Friday the 27th?
I can do it tomorrow.
Can you do it tomorrow, Mr. Quintero?
Friday.
Can you do it tomorrow?
She works, so he doesn't. What's the matter with tomorrow?
I'll see my daughter, but it's fine. I haven't seen this one in a long time.
Okay, so my order is starting today through January 25 of 2023, Mr. Quintero will have 4 hours of unsupervised parenting time on Wednesdays from 3:30 till 7:30. Based upon being in court today, exactly 3:30 at the moment, I'm going to order instead of today, the makeup parenting time for this week will be on Thursday, October 26th, 3:30 till 7:30. And it will be a supervised exchange. So starting today, October 25 through January 25 of 2024, 4 hours per week, Wednesdays, the exchanges will be supervised. Beginning on January 25 until April 25, Mr. Quintero will have 8 hours of unsupervised parenting time per week, and the supervised exchange requirement is discontinued effective March 25 of 2024. January 25, 2024. So it's supervised exchange from starting today through January 25 of 2024, then March.
The rest of this is all fluff, really. It's just, getting to the specifics.
I had this all sketched out. Now I've lost my paper. So October 25 of 2023 to January 25 of 2024.
She has to rule now.
4 hours supervised exchanges, and they're on Wednesdays except for this week. It's tomorrow, 3:30.
She made like two amended rulings to this, because it was all just done last minute on the fly right there. Because this was in the middle of another trial for her. This was an expedited motion and all that.
Unsupervised time increases to 8 hours per week, and that'll be for 3 months. So January 25 of 2024 till April 25, 2024.
Judge, who did you have in mind to do the supervised exchange?
Well, Mr. Quintero was suggesting the 5 H's, and that's what Judge Sklar ordered, so it's going to still be the 5 H's. Then starting on April 25 of 2024,
so that's all
the
the rest of
parties
this
will
is.
revert back to the parenting
But
plan
anyway,
outlined in November 8, 2019.
so the last video I had uploaded to live about my big win in court, it was this.
It says that it's every Saturday. I don't think that they're going to want every Saturday.
No, I modified that already. So you're going to follow the 8 hours that I put in my in-chambers ruling after the mom respondent's request for relief under Rule 85.
So, okay,
So it's every other weekend.
Okay, all right. And as far as cost, that should be shared equally.
No, Judge, that's.
No, the cost of supervised exchanges is
Just
petitioner's expense.
just details. But
And I'm also ordering Mr. Quintero may not take the child outside of Pima County absent
obvious.
court order.
And it seems like that's pretty much it. Anyway, so I know that the
that's
last
why
few
I'm
minutes
motion under Rule 85B6 to modify what
kind of
Judge
dragged,
Sklar did because
you know, because the
Quintero
big
had
thing
never
was,
completed that
you know, just the
incremental
main points. They
increase.
didn't meet
And
their
I'm following
burden
Judge
of
Sklar's
the rules they invoked.
intention of having
The
a
only thing that
graduated
had validity to the
of
argument, which I
supervised
said, was
parenting
just that
time, with the first 3
the
months being
planned
supervised
outline
exchanges
wasn't followed.
and the remainder
But other than that, you know, the bond was
increasing
lifted,
time
and I
and not
came back
requiring supervised
from
exchanges.
zero contact
And
with
Mr.
my
Quintero
daughter
will pay the cost of
to
supervised
all
exchanges
of
for
these
these
little
first 3
requirements
months.
that they asked me, everything that I did, and all I am is just a
Um,
spectacular father.
So
And,
with that said,
you know, and that's where I've come back from.
Mr. Wintery, I haven't read the motion to dismiss
And
your
so,
request for temporary orders and modification of parenting time. I believe the modification of parenting time was filed less than a year.
Oh.
But now the year has expired.
It's been a year.
But, so if you want to refile, it will take care of that
Refile,
procedural technicality
because the other one was
that Mr.
untimely.
Quintero
I
was
was right.
arguing. If you think there's good cause to proceed on it, even though you filed it in less than a year, it was about 4 days shy of the year. Procedurally, it might be a lot cleaner to just refile it now that the year has expired.
Well, the court has addressed the merits by, obviously, the content of our motion was for you to leave the bond requirement in place
He's still
before
arguing.
he can take this child. The court has
Still
denied
arguing.
that and has removed the bond restriction. I wouldn't expect if I refiled it, I have enough respect for this court's calendar.
Okay, do you want to withdraw the motion or the petition for modification of parenting time? Then, it sounds like that's what you're saying, or?
I understand your point. We'll refile it. I believe it matured and was appropriate as at the same time the bond requirement was lifted under Judge Sklar's ruling. I believe my 411 motion is good, but I understand the court's concern. And I'm concerned that the court's, the optimism in the court's ruling is not going to be borne out by Mr. Quintero's conduct. So I will refile it.
All right, well, if something happens, it's, you know what to do. But I want to explain my reasoning. I feel like Mr. Quintero has repaired the damage that he did to his relationship with his child in the quote-unquote kidnapping event. In her eyes, I know that he hasn't done that in the mother's eyes or her attorney's eyes. However, I feel like over the course of a year, with significantly suspending the liberal parenting time Mr. Quintero had, hopefully Judge Sklar caught his attention of how inappropriate that was, and maybe Mr. Quintero will approach things more reasonably to avoid, again, going back in time with bonds or limited parenting time. I feel like his attention has been caught, but if I'm wrong, either side is welcome to file something to ask me to do something else to protect the child's best interests.
So I could file a modification as well, correct? Obviously, because you're not making a new final ruling, we're just making a new schedule.
Well,
So Judge, if he's gonna ask the court for legal advice,
yeah, I'm not gonna give you any legal advice, but procedurally, if you wanna file something, you can file something, and if the other side thinks it's not appropriate, they'll file something in opposition.
All right.
So thank you all for coming. Any exhibit that was brought and not offered or admitted, it will be released to the party that brought it. And for now, today, I'll find that the orders I entered today are pursuant to Rule 78B of the Arizona Rules of Family Law Procedure as final orders. However, it appears that there are matters remaining pending on motion to dismiss, the petition to modify parenting time, and for temporary orders. All right, thank you.
thanks for making the time.
All right, you're welcome.
And that was that. So basically, whatever was pending, which was their petition to modify, she denied it. It was untimely. She denied that, and the bond was lifted, and we're now 3 months in, and they've already threatened to not produce my daughter as of next week, because just simply because, like in this order right here, is because you see it right there, it doesn't give a exchange location. So they're alleging because there's no compromise on the exchange location, then there's going to be no exchange. So as of a couple days ago, I have already filed another expedited motion to enforce, because these people are just awful people, you know. And I've tried compromising with them, and they want to try and come and exchange at my place, and I don't want the baby mama coming to my house because she's been violent several times over with me, my family, with Uber drivers and stuff like that. So no. So that's where I'm fighting that, and I filed another expedited motion. And I filed a modification as well, which was timely. So I filed for a modification. I included the affidavits, and we're doing this all over again. You know what I'm saying? Except I'm not going backwards. I'm going forwards. I'm seeking legal decision making. You know, yeah, I'm coming. I'm coming. If y'all have any questions, if you feel to leave comments, whatever, questions, anything, all that good stuff, you have my email. Just give me some patience and all that. I do ask, like, each and every time when you email me, that have your paperwork ready. You know, I was on the phone with the guy, like, the other day for 2 hours, and 1.5 hours of it was him telling me of his situation. And then when I looked at his document, I'm like, we just wasted 1.5 hours. Your document told me what was happening because you didn't even know what's going on with your case. I read his document back to him, his court order back to him, and completely outlined what he needed to do. Pay attention to your case. It's your case. Pay attention to it. If you're going to email me, have your documents ready for me to see. I need to see, okay? I don't give legal advice. I'm not doing that. I'm basically just reading your court order back to you, because a lot of y'all don't even understand what it says. You know what I'm saying? And that's really, like, most of the time, the court order, if you're asked, like, the number one question I get asked most of the time, I need some direction. I need some advice. What am I going to do next? What should I do next? I'm like, all right, let me show me your recent court order. I'm like, look, it says right here what you need to do next. You know what I'm saying? So, but anyways, all right. Catch y'all next time.